चेयरमैन TLSC DH पोरा जनाब निसारुल हक साहब से दरख्वास्त करूँगा कि वो तकरीब करें और अपने तजुर्बे से यहाँ इन सामीन को महसूस करें।
Thank you very much. Before commencing my deliberations upon the topic, I can see the sluggishness on the faces of all the participants. I seemed quite apparent and explicit that you people have engaged today. And same used to happen to we people when we were in the colleges, we were engaged for some sessions, we don't used to like it. But it was a deliberate attempt on my part to choose Degree College DH Pora as this institution for deliberations upon the topic which we have choose for on behalf of the District Legal Services Authority in collaboration with the Tehsil Legal Services Committee DH Pora. So I seek apologies for commencing this late session, and before commencing, we have here the Honorable Principal District and Sessions Judge and Chairman District Legal Services Authority, Mr. Nissarul Haq Khan. We have with us SDPO DH Pora, Principal Government Degree College DH Pora, President Bar Association DH Pora. We have senior members from the bar, participants today, the professors who have teach here. Thank you very much all for bearing us for such a long time. To me, justice is not a comprehensive term and it can never be. It's a subjective and a relative term. Different people sitting who are here, if you ask anyone what is the definition of justice, every person will be able to give a different connotation of what justice means to him. Because we cannot weigh and scale justice in same parameters. For example, if a person who has stole gold of a daughter of a person who is about to marry 2 days later, and a person who is famishing with hunger and he stole a loaf of bread, whether these two persons can be directly together? I think no. Though they have committed the same offense, but the gravity of the offense is entirely different. Whenever a person is aggrieved of something, his rights have been infringed, he is aggrieved. What he used to do before coming to the courts, before knocking the doors of justice, what he used to do in the society, he will approach the local Mohalla committee for redressal of his grievances. Once he has done with that, his dreams are shattered there. He will knock the doors of the serpent for redressal of his grievances. Once again, nothing is done there. He will approach some exorcist. He will seek some, what we can say that taweez and all that his grievances may be redressed, but that does not affect also. Ultimately, he approached some religious place, he will tie strings and pray to the God that my grievances should be redressed. But even though he could not do anything, he approaches the concerned police, he is dejected, he is being denied the relief, then ultimately he approaches the court. Though many people, they have different connotations of what justice means, but at the same time, once a person approaches the court, despite having a huge pendency of cases of around 5 crore and more than 5 crore cases in Indian judiciary, or being a population of around 150 crores population, we have more than 5 crore cases pendency in Indian courts nowadays. We cannot see it from the aspect that there is a long pendency of cases in Indian courts, but at the same time we can see the belief which the people are placing in the courts for seeking the justice. They are again knocking the doors of justice at the penultimate hour when they cannot see any sort of relief from any side. They approach the court, they knock the doors of justice, they file a petition or they file a case, and they say to the person, common man, I will sue you in the court of law. Now, we will come to another aspect, whether always accessing justice that costs you that costs your pocket. No, it's not always that. The Indian courts and the Constitution of India has provided for legal aid services committees. On the broader side, we have NALSA, National Legal Services Authority. On the state level, we have State Legal Services Authority. And at the peripheries or at the district levels, we have District Legal Services Authority. And in Taluka courts, we have Tahsil committees, Legal Services committees. A person, whoever finds that he does not have a relief anywhere, he does not have enough money to pursue his case, he can file a simple application before any of these courts that my case is like this, I cannot pay a lawyer, I cannot engage a lawyer. Owing to my economic constraints, I seek that my case be pursued. Owing to all the situations, what the courts do, we ever do to provide him a competent legal aid. One is legal aid, and another is competent legal aid. I will give you a beautiful example of a legal aid. Once I was in a court during my attachment periods, it is top of 2024. We were sent to attachments in one of the courts at Srinagar. I was sitting on the podium because I was under attachment. We were just there to observe the legal proceedings going on. A witness had come here who is to be examined and cross-examined. And this accused person, he had taken legal aid from the District Legal Services Authority. Once the witness gave his statement in the court, that was too contesting a statement, that was to be contradicted and cross-examined meticulously. But what I found there, the legal aid which was provided to the person, that was not sufficient. Legal aid is okay, but at the same time, it should be a competent legal aid who is able to deal with the case. Running through the pages of the history of the Indian judiciary and the judgments which have been rendered, I could not find a classic example like that of Vishaka versus State of Rajasthan. Most of the people here have listed about that case. They might have heard the facts. They might have heard that Vishaka guidelines are laid. But that is a classic example of ensuring access to justice. Vishaka was just a non-governmental organization. They approached later on to the Supreme Court. But the basic background of the case was there was a lady in Batheri, Rajasthan. She was a community worker in Women's Development Program. She was engaged by the government. In the year 90s, she was dealing with economic evils. She was dealing with child marriage, restraint on child marriage, dowry prohibition and all that. And in those times, people were not much aware about whether conducting child marriage is an offense or not. See the significance of this judgment. What she did, she tried to stop this child marriage. She put a restraint, but there were powerful people opposite. They were not, marriage of only 1 year old daughter was being conducted by one of the influential families in Rajasthan at that time. She was fighting for her. And despite her incessant efforts to curb this menace, she was rejected from all the sides, whether it be judiciary at that time, whether it be police, whether it be public institutions. But she fought with incessant efforts. She was knowing that she has to ensure justice for this girl. And ultimately when she was rejected and since her incessant efforts put in, she could not curb it. The other side of that case, who happens to be the influential family, they got totally irritated, and one day, during an unfaithful day, they assaulted his husband in the fields, and at the same time they gang raped this Maori girl. She was gang raped by 5 persons. Ultimately, due to deficient evidence and due to procedural lapses, the persons were acquitted. But this marked a significant difference in the Indian judiciary. PIR was filed in the Supreme Court, the Vishaka guidelines were made. Why I am quoting this case here? Because it is a classic example of ensuring justice to people. She fought, single-handedly she fought, alongside her husband, and reached the Supreme Court along with all the NGOs who supported those at that time. She was able to ensure that POSH Act was later on, and initially POSH Act was later on implemented, and 2013, and that is still a vogue. So my concern here is that we all speak what is access to justice, what is the ethical and moral obligations of the judges and lawyers in ensuring access to justice. We cannot be oblivious to the facts that courts are overburdened, but at the same time, when we work with zeal and zest, when every person who comes before the court, he comes with a bona fide, there is nothing which remains to be dealt with. I think time is running out. I cannot highlight 100 times amount of item. I could not sum up the topic in such a brief span. So, taking your leave, I conclude here. I do not find much time. Later on, at the conclusion, I will say, the foundation of the tyranny, they don't endure forever. But the ray of justice that pierces the darkness and sets the dawn. Thank you.
शुक्रिया जनाब निसारुल हक साहब